The decision that Judge Torres made in the Ripple case, which has been a sensitive subject for a substantial number of people, has been challenged by the Securities and Exchange Commission, which has filed an appeal against the verdict. Following the spread of the news, a film that was made available to the general public and featured the perspectives of a number of solicitors was prepared for public consumption. The CEO of Ripple, Brad Garlinghouse, was one of the attorneys featured in the video. Jeremy Hogan, who was also featured in the film, was also named as one of the attorneys featured in the video. The viewpoint of a lawyer who was not actively involved in the case has been expressed. As far as the implications of the decision that was handed down by the Securities and Exchange Commission are concerned, Hogan is not involved in the case. He is of the opinion that the Securities and Exchange Commission has made a significant mistake by appealing the ruling regarding programmatic sales. As far as he is concerned, this choice was handled in an improper manner. Additionally, if they are successful, Ripple will be able to collect additional payments from Ripple. Despite this, they would not have had the ability to ensure the safety of any individuals along the procedure. Until further notice, transactions that involve Ripple selling XRP outside of on-demand liquidity on exchanges are still regarded to be blind transactions. This is the case for the time being. When we talk about these sales, we are referring to transactions that are still believed to be entirely blinding from the outside. Both the preliminary complaint that was submitted by the SEC and the lawsuit that was submitted against the firm made use of these transactions, which Ripple referred to as programmatic sales. Both of these lawsuits were ultimately filed against the company. Ripple, the cryptocurrency of choice, is the entity that is responsible for giving these transactions their name. The only transactions that are being discussed here are those that are connected to the Ripple network. These transactions should not be confused with those that take place on cryptocurrency exchanges between individuals or organizations. This is a key point to keep in mind. Ripple, as well as the facts and conditions that are associated with transactions via Ripple, are the specific targets of the lawsuit, which does not target transactions between individuals or between organizations, respectively. Additionally, the case does not focus on transactions that take place between corporations. However, the Securities and Exchange Commission does not have the jurisdiction to challenge transactions that take place on the secondary market, despite the fact that XRP is subject to regulatory clarification. When it comes to the investigation that the SEC is conducting into the Ripple situation, Hogan predicts that Ripple will also ask for extra funds to assist with the probe. This is despite the fact that XRP is subject to disclosure. In addition, he is of the opinion at some point in the near future. A devastating blow has been dealt to Ripple and the cryptocurrency community as a whole as a consequence of the decision made by the Securities and Exchange Commission to appeal the verdict on programmatic sales. This judgment has had a devastating effect on each of these groups for a variety of reasons. In the event that the Securities and Exchange Commission makes the decision to appeal this finding, it is possible that Ripple will be granted access to further capital. With that being said, nobody will be shielded from the repercussions that this decision will bring about. In the event that the Securities and Exchange Commission decides to file an appeal against the ruling, it is anticipated that this decision would have significant ramifications, not only for the Bitcoin industry, but also for the greater community of people who are interested in participating in cryptocurrency activities. The Securities and Exchange Commission (SEC) possesses the authority to appeal decisions. The reason for this is not because the issue with the Blue Sky Law has the potential to weaken the ability of the Securities and Exchange Commission to exert control over the whole cryptocurrency business. Ripple is experiencing a great deal of anxiety with the current situation. Ripple specifically mentioned that certain aspects of transactions that were based on Blue Sky standards, such as duties to the Postal Service, would be subject to postal requirements. This was one of the provisions that Ripple mentioned. These words were spoken within the framework of the Blue Sky regulations. In addition, the Blue Sky laws were used as an example to illustrate the point in order to make it clearer. The Securities and Exchange Commission Act of 1933 is a piece of state legislation in the United States that regulates the offering and selling of securities. The purpose of this legislation is to protect all members of the general public from being harmed by fraudulent behavior. The state laws that were enforced throughout the course of the years leading up to the passing of the Securities Act of 1933 by the federal government contributed to the establishment of a precedent in the law. Due to the fact that the judge's decision will be substantially reliant on facts, these statutes served as the foundation for the establishment of legal precedent. There is a substantial possibility that the Securities and Exchange Commission may not be successful in its endeavors. This holds true not only from a statistical standpoint, but also with regard to the actual verdict itself. If the SEC were to prevail in their appeal, Attorney Hogan believes that the scenario regarding XRP and Ripple's utilization of it would not change even if they were to win the case. This is the viewpoint that Attorney Hogan is taking in this article. A conclusion had been reached by the Judge Torres regarding one of the components of the Ho test, and the client was informed by the attorney Detton of this accomplishment. The clients were thrilled when they made the discovery that they were aware of this information. In light of this, it is feasible to draw the conclusion that in order for something to be able to pass the O test, it must be capable of satisfying all of the components that make up the O test. She is able to exercise this competence in the event that the Securities and Exchange Commission is reprimanded, and she is also in possession of the authority to rule on the other prongs, which are likewise skillfully organized in that manner. However, you have another problem that was brought up by Attorney Hogan, and that is the fact that even if the Securities and Exchange Commission were to prevail on appeal, it would still be a subject of personal financial advantage. One of the things that was brought up by the attorney was mentioned here. In this particular instance, one of the issues that was brought up by the attorney was mentioned. The initial brief that Ripple is supposed to submit must be submitted by the middle of December. In addition, the corporation has made the conclusion that it will not be able to appeal the determination that XRP and other cryptocurrencies are not securities. As an additional point of interest, Ripple is not entitled to submit an appeal against the verdict. Additionally, it is of the utmost importance to keep a vigilant watch out for any hint that the Securities and Exchange Commission wants to appeal the ruling. This is of the utmost necessity. Ripple's legal counsels have finally provided an explanation as to why the company lacked the ability to challenge the verdict about whether or not XR is considered a security. This explanation has never been offered before. It is being presented for the very first time. It is Hogan that I am referring to here. According to him, if the Securities and Exchange Commission decided to appeal the injunction, it would be exceedingly difficult for Ripple to continue to maintain its position in the cryptocurrency market. This would be the case because of the severe difficulties that would be involved. He is of the opinion that this would be the best choice. Ripple is extremely concerned about the blue sky law issue because it has the potential to undermine the SEC's ability to monitor the entire cryptocurrency market and turn it into a poor stock trader. This is a source of tremendous concern for Ripple. The reason that Ripple is so concerned about the matter is because of this explanation. One could draw this conclusion from the remark that came before this one. But this is the probable inference that could be made. An ongoing legal battle between Ripple and the Securities and Exchange Commission has been going on since the 13th of July of the previous year. The purpose of this paper is to provide an outline of the ongoing disagreements that are taking place between the two sides. Due to the fact that he introduced it as a dictum, it became procedurally undesirable. This ruling was rendered by the court when it came to the conclusion that the Securities and Exchange Commission did not constitute a security. After the end of the court's decision, this action was carried out with the appropriate consequences. In addition, the Securities and Exchange Commission has informed the public that they are not conducting an investigation into the topic of whether or not Ripple would be considered a security right. At this very moment, in view of the fact that the SEC's objective is to ensure that Ripple does not violate any Section 5 violations. Due to the fact that this purpose was achieved, the injunction that Attorney Hogan had suggested was taken into consideration. In order to accomplish this objective, the injunction was imposed. In spite of the fact that it is predicted that the verdict from the appellate court will be handed down in the latter half of 2025 or the early part of 2026, it is quite doubtful that it will have any impact whatsoever on the average holder of XRP. It is anticipated that the verdict will be handed down within either of those two time periods, which is the reason for this. In light of the fact that the appeal was submitted on the same day that the lawsuit against J. Clayton Ripple was filed, Attorney Hogan believes that the timing of the appeal is unconventional. According to him, this is a problem that needs to be addressed in order to be resolved. In addition, the summary includes a notice of the fact that the attorney Gerber Gurrell resigned from his position with the Securities and Exchange Commission on the same day that the appeal was submitted. The summary incorporates this new component as a part of its overall structure. This is a reference to the prior event in which J. Clayton Ripple was sued and then left the agency when the lawsuit was brought against him following the termination of his job. Following the lawsuit, he left the agency. Ripper is currently serving as the Director of Enforcement for the Securities and Exchange Commission, and the appeal is particularly remarkable due to the fact that it took place on the same day that the appeal was met. As a result, the attraction is a little bit peculiar.